All right, good morning. I have 8 a.m. Eastern Standard Time here in the great state of Georgia. If you would bow your heads with me real quick. Lord Jesus, we thank you for this day. We thank you for all your blessings, Lord. Thank you for seeing us safely through the weekend, Lord. We ask that you be with us here today, Lord. Help us do what would be pleasing unto you, Lord. We ask these things in your sweet and holy name. Amen. First order of business, it's not on your agenda. Per our rules, I am going to move that we change our quorum requirement to 50 plus 1, which would basically be 11 instead of the 5. And so that is what I'm going to suggest to the committee first off this morning. Motion is second. Any discussion? Hearing none, all those in favor, let it be known by saying aye. All those opposed, no. Okay, congrats. New quorum rule, 50 plus 1. Okay. First bill we will hear today is House Bill 139 by Representative Crow. Which number you? The button not working.
Michael, the president will use 15.
Hey, there. All right. Representative Crow. Yep. And Representative Crow, just to preface, we are working off of LC 491160.
This is a bill that we had last session. It was House Bill 895. During last session, passed this committee, passed the House, got all the way to Senate rules. We just couldn't get it out the last day. So
Clint, I don't think we're picking you up. You might have to move to another mic.
my light's on.
This one's on.
I just get over here closer to Matt.
That'll work. Thank you.
We're friends. It's fine. Anyway, Mr. Chairman, this is it was House Bill 895 last session. GBI bill that got all the way through 2 Senate rules. We just couldn't quite get out of there on the last day last year. So what it does currently, sworn law enforcement officers that are witnesses in a case for the prosecution are not required to give their personal information during discovery on the witness list, as far as home address, phone number, personal phone number, things like that. Those protections do not currently extend to crime scene technicians, lab technicians, DNA scientists, that sort of thing. And so this bill would seek to fix that and give those personnel the same protections as sworn law enforcement officers when they are testifying due to their employment in a case. There was a couple of things we worked on last year, a couple of questions about how to contact them. So we cleared up some language working with PAC and Gactel during last session, and got all that worked through. And I would just submit it again for consideration, and hopefully we can get it all the way through this time.
Good and concise. Thank you. Is there anybody here that wishes to testify to House Bill 139? Anybody? Okay. All right. Discussion by the committee. 6. Who's 6? Representative Miller.
Thank you, Mr. Chair. Just a quick question for you, Representative Crow. Normally, during the course of due diligence for defense attorneys preparing for trial, there might be the need to run a GCIC on lay witnesses to see whether or not those witnesses have been convicted of any kinds of crime for which they could be impeached. I do not foresee any reason why people would need home addresses and home phone numbers and other personal information like that. But would your bill make it more difficult for the defense for, let's say, a non-sworn former law enforcement employee who's been gone for years, who may have gotten into who knows what, for the defense to ascertain that by doing their due diligence and running a criminal history or criminal background on that witness.
Okay, there we go. We're gonna get these buttons worked out before it's over with. I don't know that it would. So it does say that they're not required to be furnished a home address, date of birth, or home telephone number. So without the date of birth, I assume that could be an issue. But you know, these folks are crime scene technicians, and they are lab scientists that have been vetted primarily by the GBI in most cases. I think that's where it would be most applicable in this case. So I don't know that that would be an issue that you would run into. I mean, the same would be with a law enforcement officer, and these current protections extend to them, and they could be ex-law enforcement officers as well. So the law currently stipulates that for them. We're just trying to give the same protections to these folks that are, you know, presenting evidence and evidentiary information in these cases. So if that's a problem, then it would extend to law enforcement officers as well, because they currently don't have to provide that information. So I don't know how you get around that now. So these would just, it would just provide, like I said, the same information, the same protections to these folks that are, you know, required to testify because of the job they're doing.
May I follow up, Mr. Chair? I am far less concerned about law enforcement. They are post-certified. It's just, in my experience, some of these individuals, not all of them, they're just regular people, just like you and me. And I have personally, in my experience, had to impeach non-sworn law enforcement agency personnel for all kinds of things. Mm-hmm. And I'm just wondering if there could be, if the date of birth, the requirement that the date of birth not be revealed is as necessary to protecting their homes and their personal sort of information. I guess the idea is you don't want people showing up at their homes or harassing them in any way, mm-hmm. having that information in the public sphere. But do you think there could be some mechanism by which your bill could be amended to allow for the prosecution to provide to the defense dates of birth for non-sworn employees, but not file those, let's say, in a witness list, or provide for a GCIC upon request of the defense, if that's appropriate?
Yeah, I think, yeah, Mr. Chairman, can I have Nellie from the GBI respond to that?
Sure.
The committee.
Good morning.
Good morning. My name is Nellie Miles. I'm the director of the Office of Public and Governmental Affairs for the GBI. And Representative, I just wanted to kind of speak a little bit to your questions about why the GBI maybe approached this. For our non-sworn law enforcement officers, especially coming from the crime lab, just so you're aware, as far as the GBI is concerned and where the issue was, the background investigation to work for the GBI is equivalent. So they have to go through an intense background investigation, just like our GBI agents, take a polygraph test. I know I submitted to it myself. I worked in a crime lab for 16 years. I thought I was under investigation myself. So though I do understand your question, but I wanted you to know, as far as the GBI is concerned and all of our non-sworn scientists, that they have to undergo the same scrutiny that the law enforcement officer goes through. And our main thing was that when we had some of them testify, we did have defense asking for the personal information that's identified there. And so we just asked for our scientists to have those same protections that our sworn staff did. So I just really wanted to kind of explain that background. I know last year we went through it, and you didn't have the opportunity to hear that there, but I wanted to sort of put that part out there.
Desmond.
Thank you, Mr. Chair. So I think if I'm reading this correctly, I might be asking the same question. Mine's about section 50 to 52 in reference to formerly employed, non-sworn may use the address and phone number of the last agency he or she was employed. And I guess my question was, what's the duration of the benefit for the non-sworn employee after they have left the job?
I don't know that there would be an expiration on the benefit of that. It would just be if it was a case pertaining to something that they did while they were working there.
Okay.
And that was actually that was a concern that Gactel had last year. And so we worked with PAC to kind of craft this language to give them a way to be able to find them, because they do change agencies sometimes. And we want to make sure that they still had a requirement. And this puts the onus on that witness to make sure that their information is kept current so they can be located.
Okay, thank you. Thank you.
Number 17. Fleming.
Thank you, Mr. Chairman. Back to the issue representative of adding the date of birth, making it allowable. You actually wouldn't just be changing the bill, you'd be changing current law if you did that. If you look on line 18 of the bill, it says that you're not allowed to give out that date of birth. So if it's already in current law and we haven't had a bill to change that before, I don't see why we'd want to start that now.
Thank you. Representative Miller.
Yeah, just to thank you, Mr. Chair, just to Representative Fleming's point, I think the current law is, as I understand it, that you cannot have the date of birth of a law enforcement officer. And I guess my issue is not with law enforcement officers. I completely understand that. My issue was with the non-sworn employees of law enforcement agency who could be a crime scene tech. And I know that GBI now understand the background check that GBI does for their non-sworn employees. And I wonder if perhaps the witness could testify to whether other agencies also do a similar kind of background check. So for example, APD or DeKalb County PD, or it is really just, my questions are really just concerning non-sworn employees who are not post-certified police officers and withholding their dates of birth. So.
Speak to the local law enforcement. Mike, I don't know if you can speak. Is Mike still here from the sheriff's office? Can speak to maybe the sheriff's offices, generally the background checks.
Good morning.
Mike, if you would come to the microphone.
I don't know if Butch is here from the chiefs.
And just make sure you identify yourself and who you're with.
Morning, Mr. Chairman. Members of the committee, my name is Mike Mitchell. I'm with the Georgia Sheriff's Association. And so the background check that the sheriff's offices do here in the state is pretty consistent with what the GBI does. Obviously, they may not have the same resources, but it does consist of a full criminal history background check.
Okay.
Driving history, credit history in some cases.
Okay. Any questions?
Is that?
All right, go ahead.
Am I on? Is that background check done periodically or just at the point of hire? So for example, if an employee is hired, I'm assuming that's when the background check is done, but do you periodically do them as the years go on?
That I'm not sure of. I'm not sure how the GBI does theirs, but I do know it's done at the point of initial hire, but I'm not sure if it's done on a regular basis.
Thank you.
Representative Crowe.
Just a quick question. So to her point, if you did need to, as a former law enforcement officer, I would like to think this would never have to happen. But if someone left the the agency and was later a witness, what would you do if you had to impeach a former law enforcement officer as a witness currently? I mean, I have to imagine there could be a time when that would happen as well. So, you know, however you would do that, I think you could do the same thing here, could you not?
Are you asking me?
Yes, ma'am.
Oh, I'm sorry.
Yeah, you were a prosecutor, so
I
I
was.
thought you might know.
I was, you know, I would say that most folks would request certain information, personnel file information on the officer, conduct public record searches, Google, things like that to figure out if the officer has ever had any issue that warrants, you know, follow-up. I just, in my mind, I just view law enforcement officers as different than non-sworn employees who just have different requirements, different certification requirements. And so that was my concern. Many of them tend to float around from job to job, going from the public sector to the private sector, back to the public sector again. And so my concern, as I said, is not with protecting their home information and things that might identify or put them in harm's way, but simply allowing the defense to do their due diligence when they are preparing for trial. So I do understand. You know, after giving it some thought, I do understand what the point of this is, and am in support of it. But was hoping that there would be some mechanism for the defense to, if appropriate, request the kind of information that would allow them to conduct the kind of investigation that the law requires that they do in zealously advocating for their clients.
And Representative Crowe, I can say from experience in my practice that every time I have a officer involved, I request post records, I request personnel files and their GCIC if they should have one, and also policies and procedures of the department. So one question I had, and I may have asked this last year, I was trying to remember, but as far as if defense counsel has to subpoena an officer and you're faced with a situation where you're trying to get that information, and let's say that the law enforcement agency determines this to be not material, which was going back. You'll see in line 67, 68 there towards the end, questions as to his or her home address whenever such fact may be material to any issue in the proceedings. So let's say that that agency where this officer has provided his last or most current address to, they have a contention over to where this fact is material, because it may reflect badly on their investigation of the current case. And so that sets up a situation to where you have to go before the judge and have a hearing on this matter as to whether the issue is material. So that was a scenario I had in my mind that I was trying to wrap my head around. It was like, well, what if I have to subpoena somebody and then the law enforcement agency determines that it's not material and we have to go to the court? And I mean, we start clogging the courts up with what's material and immaterial. What are your thoughts on that?
Well, I think as Representative Fleming said earlier, that's current law now for law enforcement employees, and all we're doing is adding the non-sworn employees the same protection. So if that's an issue now, then it would be an issue then. But yeah, I don't know that it would be substantially more. So you'd have more experience in that than I would. But this is simply trying to bring parity to these folks that go to work, and they're often now with DNA evidence and scientific evidence in these cases. Many of these cases hinge on these folks' ability to do their job, and they could become a target if somebody wanted to sway their testimony or keep them from testifying. And so we're trying to make sure that they have the same protections that the other pertinent witnesses in the case have. And that's it.
Representative Neal.
Thank you. This to the author. Just a quick question. So when you say non-sworn, excuse me, confirming, you mean like this includes like records clerks and those persons as well?
It could. I mean, it's a non-sworn employee of a law enforcement agency. So I take it that could mean the janitor if, but I don't think that they would be as likely to be testifying in a criminal case. So.
Representative Reeves.
Representative Crowe, this would apply to crime scene techs who were out there in the middle of the night, helping the police gather evidence on traffic accidents and armed robberies, murders, things like that, right?
Correct.
I mean, the way I look at it, these are in-person employees who are out there often, outside of business hours. These are people out in the field along with police. And I know where I'm from in Gwinnett, we've got a shortage on police officers. I would think we're fighting the same fight with getting full-time employees as crime scene techs. And if this is one more thing we can use to tell them that, that they'll be protected in the line of duty, I think it's a good thing. If it's okay for the officers who are out there responding to these incidents, then I think the people on their team ought to be protected as well.
Thank you. Representative Neal.
Thank you. So I think what I'm hearing, I guess, when it comes to everyone, there's a question of how far reaching this is. So what if it's a matter of a friendly amendment of some sort where it only applies to those persons that directly relate to the crime itself? So instead of it being so broad to say all non-sworn, what if you say crime scene techs or the specific individuals that work the course of a case to make people feel comfortable? How would the posture of the committee feel about that?
Well, I don't think that we would need to do that. If they're not pertinent to the case, they wouldn't be a witness. They wouldn't have anything to offer.
We'll have to get some more microphones in here. Representative Sains.
He made my point. It's self-selecting already by the nature of the proceedings.
Representative Miller.
This is, I guess, directed to the author, Representative Crowe. Two parts. One, have there been any situations that you're aware of where crime scene techs or non-sworn employees have faced threats or had any sort of circumstance come upon them as a result of their work in the field that would make them commiserate with law enforcement officers? And then the second question is the need to protect non-sworn employees from disclosure, in your opinion? Does it remain after they have left employment? So if the non-sworn employee, for example, quits and goes out to open a restaurant or a nightclub, and it's a cold case and we're calling them back 5 years later, do we still need to protect their date of birth such that it would preclude the defense from doing their due diligence in terms of investigating potential impeachment of witnesses?
I'll answer the second part, and then I may let Nellie answer the first part about anything that's gone on in the past. I think that question came up last year when we were going through this. I'll let her address that. But I think the reason that you don't put a timestamp on it is because the threat could still be there. The whole idea behind protecting them for me is that if they are the threat is if they are able to provide damaging information to a defendant, and the defendant would want to keep them from testifying to the case or somehow uh, coerce them into not testifying fully. That would still be present if the case is still ongoing, and that would still be a pertinent threat. And I don't think that somebody who is in that position, because they're doing their job and working, trying to help prosecute cases, I don't think they should have that threat or perceived possible opportunity for threat, whether it's been a year or 5 years or 10 years, if they're doing their job trying to help prosecute cases.
I think Representative Crowe, covered it, but the basic sort of bottom line as far as what we've seen is that we have had our non-sworn personnel. For us, it's the scientists, the DNA scientists, like he said, the chemists, get asked to have their personal information. And we're just saying that, I think, like Representative Reed said, they are working for the people of the state. They are doing the evidence that they provide and they test is helping to further that case. And they just want that same level of protection to not release their information. I hate to take it back. Remember the Brian Nichols trial? We had our scientists on the stand testifying, and that was a very scary time for all of us. And so the same threat that was faced by the law enforcement officers, same threat that the non-sworn scientists faced as well. And that could be the same for any other person, like the evidence tech that's involved in the case. Today and that time, there are a lot of potential threats that those that work in law enforcement, sworn and non-sworn, just because you don't wear the badge, again, they have to go through the same process. And we just want to do anything we can to help protect those individuals and know that we've got their backs.
Okay. Now we're in a posture of discussion from members of the committee. Y'all are a quiet bunch this morning. Okay. What's the mind of the committee? Move to pass. Second. All those in favor, say aye. All those opposed, say no. Ayes have it. Moves on to the Rules Committee. Vice Chairman Crowe, if you would get with Brian and fill out the Rules Committee sheet. Congratulations. Yes.
Can I ask for a roll call vote?
You want to go on record for it?
Yes.
Okay. All right. We will do that. You want it alphabetical? Let me get my roster real quick. Thank you. I don't know where mine went. All right. We'll just go with bottom up. Guess I'm gonna have to represent or pull up every microphone. Which one are you on? Representative Sains?
I'm on the last one. Aye.
Representative Sains, aye. Representative Roberts.
No.
Which one are you on?
I have no idea. It's a different number. Things
All
are
right.
flying.
Represent, all right,
No.
okay. Representative Reeves. Representative Reeves, aye. Representative Neal.
Aye.
Representative Farouk. Representative Farouk Mughal. Did I pronounce that right? Okay, all right. Representative Miller. Representative Miller, no. Representative Leverett. Representative Leverett, aye. Representative Kendrick.
No.
Representative Kendrick, no. Representative Hong. Representative Hong, aye. Chairman Gunner. Aye. Chairman Gunner, aye. Representative Gullett. Representative Gullett, aye. Representative Fleming. Representative Fleming, aye. Say Representative Byrd. Representative Byrd, aye. Representative Crowe. Representative Crowe, aye. Representative Silcox. Representative Silcox, aye. Chair votes aye. Right. Congratulations. Still moving on to rules. All right, moving along, House Bill 88, Representative Gaines.
Morning.
Morning, how are you?
Good. How are you? Congratulations again on the chairmanship. We're
Thank
excited to be back in Judiciary Non-Civil.
Thank
Glad
you.
I'm not on the committee. So
Yes,
y'all have
sir.
long meetings,
Yes, sir.
bunch of lawyers.
Representative Gaines, just remind us which LC number you're working off of here today.
It is LC 480754.
Go ahead.
Well, I appreciate the time this morning. I know there's several folks who want to speak on this measure, so I'll be quick. But what this legislation is aimed to do is to provide additional resources for law enforcement to help solve unsolved homicides in our state, cold cases. It's modeled after federal legislation that was passed last year, which I didn't know Congress could do anything these days, but they did pass something unanimously in the U.S. Senate last year and almost unanimously in the House, the Homicide Victims Families Rights Act. And this legislation is modeled similarly to apply to local and state law enforcement agencies to try to provide additional resources and to provide some justice for families that have been victims of these homicides, to try to bring those responsible to justice. The one particular case that I'll mention, it's named the Coleman-Baker Act after Rhonda Coleman and Tara Baker. The Tara Baker case, and the reason I'm interested in this legislation was a young law student murdered in 2001 in Athens. And it gained significant attention at the time. And since then, here recently, there's been a podcast, Classic City Crime. Cameron Harrelson, individual in Athens who led this podcast, has renewed the interest in this case and has done a great job to bring attention to it. But there are just in Athens, Clark County, I'll tell you, there's 40 cold cases since 1972. And there's a significant number across the state. But I'll tell you just high level what the legislation does, and then again, be happy to maybe hear from some other folks testifying, and we can go through the bill specifically. But it allows families, and it defines which family members would be eligible, but to apply for a reinvestigation of these cases. It creates a mechanism for reporting these cases from local and state law enforcement agencies, so we know which cold cases are there. And it also provides a mechanism for coroners to issue and really clarifies that coroners can issue a death certificate with a nonspecific, basically they can give nonspecific homicide as a means of on the coroner death certificate. One of the issues in the Baker case that was a challenge was that the death certificate wasn't issued for quite some time. Her identity had been stolen multiple times after her death. And so those are the three large overarching policy objectives in this piece of legislation. We're also working to set up a cold case unit within the GBI through the budget, and that's a separate process, but it all ties together. And so that's generally what this legislation does. I'd be happy, if you want me to, Mr. Chairman, to go through all the specifics of the bill, or we can hear from others and take questions.
Go ahead and go through the specifics of the bill for us real quick.
All right, I'll try to move quickly, but feel free to interrupt and if you have questions. But the immediate, I'll just kind of walk through. So the first line 17 through 34, just definitions, and one of which the important one here is the immediate family member definition, which sets the process for law enforcement who are family members, and basically prevents just random folks coming in and trying to wreak havoc on the process. The House version definition of cold case, there is a Senate bill on this matter as well, but is a 6-year definition. And that was requested specifically by the GBI. This legislation has, I'll mention, should have at the onset, but it's had input from everybody under the sun interested, and I don't think we've heard real opposition. There may be one or two changes out in the audience that are interested, that look forward to hearing from, but has had a lot of input. And then it walks through the process for a family member. They would submit a written application for a case. This on line 36. and the agency would review the case file. And if there are leads found, or a likely perpetrator could be identified, this would kick off a reinvestigation. Then it says what the review does, and it has certain tasks that must be performed. That's line 42. An analysis of any investigative procedure that may have been missed, check if any physical evidence were to be subjected to updated methods like DNA testing, and if that would aid the investigation, an update of the case file using the latest investigative methods. And line 58 says that a reinvestigation cannot be performed solely by the original investigator. And line 60, only one investigation at a time. Line 62, if nothing is found after the reinvestigation, this is important, the application process freezes for 5 years. So it's not constantly constantly having reapplications on these reinvestigations. Line 67 just allows the agency to develop the application, and then it gives 1 year to implement the law. Line 72, a written notice of receipt is given to the applicant with information on how to submit a complaint according to existing agency policies. Line 77, application for cases that do not meet the definition of cold cases are automatically declined, which is again defined there early in the bill. And then they're notified in writing if that is the case. The agency has 6 months to complete the review process, and if necessary, can push it out an additional 6 months if the agency is lacking resources. So that provides up to a year. Then we get into the reporting piece, which is line 97. The Carl Vinson Institute creates a publicly searchable database and collects data from each agency. And that walks through that process. And then line 108, if more than one agency has jurisdiction, the agency shall coordinate the review or full reinvestigation efforts. And line 118, pretty important. The act is subject to appropriations, state or local, applying to all cases since January 1 of 1970. And then we get into the coroner piece, which I mentioned earlier, line 124, clarifies that death certificates may be issued with a non-specific homicide if the details of the murder being released would hinder the investigation. We believe this is something that can already and is already being done under current law, but just provides that clarification. And it clarifies that the death certificate may be amended at the conclusion of the investigation. And that's the bill.
Good job. Not quite lighting up like a Christmas tree yet. I remind members of the committee, this is the portion of the hearing on the bill where we have questions for the authors. I'll implore you not to get into lengthy statements. That is more for the discussion, or I say more for, that is for the discussion part of this hearing. So questions for.
And I will mention Scott Turner's here, who has become an expert on this issue and may be able to assist if
Okay.
there are
All right.
specific questions.
We'll allow phone a friend.
Thank you.
All right. Representative Crowe, who's 16? Or Representative Reeves?
I can hold this for later or do it now. This was just general. It was more comment than question.
Hold that for later. All right, number 5. Who's got 5 over here to my left?
They're not numbered.
Who pushed the?
I pushed. Stewart.
This is fine.
I don't
That's
know.
2. Somebody hit 5 over there. All right, Chairman Gunner.
Thank you. One case that comes to mind from my experience would be like suicide cases where they've been ruled suicide, but the family doesn't accept that. And they're, it's not totally conclusive, but the ruling was suicide. How would that fit into this?
Thank you for the question. So the bill only contemplates homicides, so it would be deaths caused by another. If there were in suicides, the cases can be closed. Homicides that are not resolved or cleared remain open, as you know. So this is for open homicide cases.
Okay. All right. So it wouldn't allow a family that gets doesn't agree with the ruling.
No, it would have to be an ongoing open homicide investigation.
Okay. Thank you.
Is that Representative Kendrick?
Yes. Thank you,
Representative
Mr. Chair.
Kendrick.
You mentioned that this came out of a story from a student. Did you say a student in Athens? Could you tell a little bit about
A law
how we got-
student, and the two, it's named the Coleman Baker Act, but the case that specifically applies to Athens was Tara Louise Baker, and she was a law student who was brutally murdered in 2001 in Athens, and a case that has not been solved yet. But there was this podcast that gained, I think it's got, hundreds of thousands of listens, and has gained some national attention to that case and to this issue in general. And so that's what I was referring to. Thank you.
Representative Gullett.
Thank you. So what do we do about agencies who are just super small? Say like an agency has one investigator. I know there's 6 months and then there's 6 months to extend it. I think it's a good idea. I'm just trying to understand the mechanics of what does an agency do, especially since agencies are short-staffed kind of across the board in that situation.
So Representative Gaines had mentioned the parallel effort to fully fund a cold case unit within GBI. And so the GBI acts today as a support unit for local law enforcement agencies. And our hope would be that the resources being there, that they would leverage that more readily than they do today, especially these smaller agencies. And what we've also found in talking with a lot of small agencies is that they simply do not have a lot of cold cases. I'll use Oconee County as an example. Speaking with their sheriff, he told me that he was aware of 4 cases that they have, and they're constantly trying to look at those. So it's a combination of fewer number of cases and a greater number of resources being committed to it from a state perspective.
Can I have one follow-up? Thank you. That's a fair answer there. And the reason that we only do homicides, not like aggravated rape and things like that, is because why? One, because the case is still open until it's closed.
Yeah, there's no statute of limitations on murder.
Yep. Thank you.
All right. Number 11, Representative Hall.
Thank you, Mr. Chair. Approximately how many cold case files do we have pending, and are they concentrated in one area, like more in the city, certain counties?
So again, this is just an example. In Athens, Clark County, there's 40. We really don't know, and that's part of the legislation, is to provide some reporting. Do we have a number on the GBI?
The GBI, in collaboration and working on this bill, let me know they have over 500 cases under their jurisdiction that they consider cold murder cases. That is only the ones that they have been asked to participate in by locals. We have no idea how many there are statewide.
Let's see. Number 14. Chairman Ledford.
Chairman, thank you, Mr. Chairman. Thank you for bringing this legislation. I think this is a very important issue, and I remember that case that you discussed. I had one that's sort of a technical question, and another question that's just sort of a broader, for my personal edification. The way you've structured the statute, the crime would have had to have occurred more than 6 years before the date the immediate family member makes an application to reinvestigate. Am I reading that correctly?
That's right.
And customarily, we talk about closed cases. The case doesn't necessarily have to have been closed. And is that even such a thing? I mean, is that just a sort of a colloquial term that we use when we're talking about criminal cases that haven't been resolved?
That's my understanding.
Yeah. So, an unsolved homicide never closes. So,
because you can always indict it since there's no statute of limitation. Right. Okay. So this is the 6 years really is just trying to make sure that we're not overburdening the local agencies by having these requests occur before us. A reasonable amount of time has elapsed where you would think there's a need to reinvestigate.
And the federal bill has 2 years, but the 6 years does provide some additional, to your point, not overburdening law enforcement agencies. And that was a request of the agencies.
Okay, thank you. One other question, Mr. Chairman. This is more just a nuts and bolts. I noticed the term probative lead is defined on lines 32 to 34, but a term probative investigative leads appears a few times in the statute. are those the same thing or is there a distinction between the two?
It's an intention for it to be the same.
Okay.
All right. Whenever.
Thank you, Mr. Chairman.
Yeah. Thank you, Mr. Chairman. Whenever one of y'all are talking, give me just a second. I'm having to push buttons left and right. So y'all are.
Sorry, Chairman.
Just chill for a minute. All right. Number 8,
That's me.
Vice Chairman or Chairman Silcox.
Thank you, Mr. Chairman. Thank you so much, Representative Gaines, for bringing this. I think this is particularly important in light of the DNA evidence that we have now, since, it does go back to 1970. And I guess I would anticipate that, a lot of these would be using DNA evidence to update and see if there's a possible lead that wasn't discovered previously or what have you. But I know that several years ago, we established the storage for the rape kits. And I know this would only apply to murder cases, but I would hope that they would coordinate with the rape kit unit in terms of rape murders. And I think that that's another great potential application of that other state resource. Did you anticipate that or?
I'd let the GBI answer questions about how they would organize. I can only, they've told me some ideas that they have, but I don't know how they would plan to.
Okay, thank you. Thank you for bringing the bill.
Yeah.
All right. I have several questions. So indulge me for just a minute. Line 20, and this is in the form of a question. You have the word murder there. Cold case murder means a homicide. Well, homicide in Georgia is a pretty broad term. It encompasses any killing of another human being, unless legally justified, obviously. And it can include murder, manslaughter, depending on the actions and state of mind of the perpetrator. I mean, you've got involuntary manslaughter, voluntary manslaughter, malice murder, felony murder. So if the bill author would be open to the chair's suggestion here that a simple fix to this, just not to put it within the confines that you might not want to, would you be open to striking the word murder from that?
Yes, sir.
Okay. All right. And yes, line 20, just strike the word murder. Okay. No, just murder. No, just murder. Okay, and this will be a question for PAC here later on. My concern to the bill author, and I would be open to this either way for uniformity's sake. I would be interested if PAC had some kind of model of procedures that they would have to adopt to evaluate these cases. I don't know if y'all have anything on there, and this can wait till a little bit later. Just be thinking about that. I'll come back. And if the bill author would be open to something of that nature, just to make it uniform across the state. Because when I go to Fruitland County, I may be facing something totally different than I would in Irwin. Just food for thought there. There is a question I have, and this is for the whole, basically last paragraph altogether, lines 121 through line 137. I have some real concerns about this provision. It was not y'all's intent, I know. You read through this, and basically this is already within the code section 45-16-24. There becomes the issue in my mind here, and I just wonder if you share this and would be open to it, but it's talking about a determination at the agency's sole discretion and whether it would hinder the homicide investigation. is there any instance you can provide us with to where the release of or the issuance of a death certificate would prohibit a homicide investigation? And the reason I ask you is why, reading this language, if a agency in their sole discretion as the bill is written determines that this would hinder a homicide investigation, they could hold this up for a while. And I understand the provision down here about the probate of the estate, but having done a little bit of probate work myself, probate court judge and banks, when you're trying to open an executor's account, they're not going to move without a death certificate. And so while I appreciate the verbiage there in those lines 135 through 137, basically trying to throw a feather at something in the chair's opinion here, and is not really going to override what you're doing here. But I guess I'll break that down. I would ask you, when would the issuance of a death certificate hinder a homicide investigation? Can you speak to that?
Scott, you can go. I mean, the thing I'll mention is it like in the Tara Baker case, that I mean, how many years was it? 10 years the death certificate was not issued because it was said to be a hindrance to the investigation. And so her identity was stolen. They couldn't complete the probate. And so that's what this is aimed towards.
Did the coroner withhold the certificate? And there's nothing else within law that would hold that coroner accountable?
So no, today it is their sole discretion. What we've tried to do is clarify that coroners, medical examiners, they have the ability, the legal authority to do this today. We have certain coroners who have put families through a decade or more of anguish with not being able to receive a death certificate to close out the affairs. And the Tara Baker case is the most glaring example. That's the 10-year bad high watermark for this particular type of situation. And talking with coroners, our own Representative Mathis, as you know, was a former coroner. He was adamant they have the authority to do it today. So we weren't trying to put any type of mandate on coroners saying they must. We were trying in an attempt to clarify that they have the authority to do this. And that's why it says in their sole discretion, and that they can go ahead and issue a death certificate with non-homicidal or non-specific homicidal means. It's not a mandate per se. It's a clarification of the code that exists today.
Thank you for that, Representative Emeritus. I'll point this out. And sorry for not recognizing you as such earlier.
You don't
Good to
have to
see you again. I would say that the way this is written, this gives law enforcement agency, district attorney's office, basically veto power if a coroner wanted to issue the death certificate. And so that seems to be problematic in the way that's worded. I mean, you're giving clear veto power over another duly elected official to another elected official. I mean, how does that check and balance work there? Because it's at that agency's sole discretion. And I'm sympathetic to the situation that you outlined in the example of the case that's the namesake for this. Seems to me to be a political solution there, and not having to give veto power over the coroner's office to somebody else.
They already have that authority though, Chairman. It is their discretion. You can't force a coroner or medical. There's no mechanism currently contemplated in law to force a coroner to issue a death certificate if they don't want to.
Follow with me though. What I'm asking is their ability, the reading of this gives them now the ability to prohibit the issuance of a death certificate.
Mm-hmm.
So you're saying with the word at the agency's sole discretion,
Did you
suggesting
struck
that's
that?
the law
Right.
enforcement agency.
Right.
Maybe get rid of that clause.
Well, since you brought it up, the whole
Or the whole thing, whatever you want, Mr. Chairman, we're with you.
and look, I've been here since 5 o'clock this morning going over these two bills, and this one in particular, and lines 121 through 137 if you would be open just to striking that whole provision,
All of it?
all of it. Because, looking at this, I mean, if there's an investigation of a cold case that comes along and there's a determination that this was murder, involuntary manslaughter, voluntary manslaughter, the coroner under the current statute can go back and issue a death certificate stating the actual cause of death under the statute, which is Code Section 45-16-24. And so if you would be open to it, I just, in my mind, we're trying to limit corruption that could occur here. And I
That's
know
right.
y'all are aiming at
Yeah, that's the whole
corruption,
goal.
but by trying to solve one source of corruption, we may be creating another. And just with the office of the coroner, I don't know how many of our coroners or medical examiners out there are listening, but this is just a balance of power within these political jurisdictions of the state that I'm worried about. And, you have to read that very carefully and read what it's also saying that's not spoken within the words and how the statute could be interpreted. So if you'd be open to it,
I am, would ask as Bill moves through the process, if we could just keep in touch on that. If we come up with better language further down the road, I'd love to keep in touch with you. But for today, I'm comfortable with that.
Sure. And just so you know, that's just a question at this point. We'll have to see how the committee feels. Who's number
I suspect you have influence over the committee.
You know what? It's a democratic process. Who's number 17? Representative Fleming.
Thank you, Mr. Chairman. I'm trying to understand this point that you're making. So currently, a law enforcement agency does not have the authority to tell the coroner or medical examiner, do not release a death certificate because it will harm our investigation. That's a question. Do they have that authority currently?
I don't believe so. And actually, and maybe I'm wrong, but I don't think that was even the policy objective here. But I see what the chairman is saying on line 126. But no, I don't believe under current law they have that authority, and I don't believe that was the goal. I do think that potentially just striking at the agency's sole discretion would solve that. I think, but I'm thinking on the fly. But
well, agency on line 126 refers to the definition of agency on line 18
Right.
under this code section,
Right.
which is a law enforcement.
right.
So I suspect whoever wrote it was thinking agency referred back to the medical
Right.
examiner. But
And I see that.
it is not. That's the
Correct.
chairman's point. I
That's
think.
right. That's right.
Okay.
And so I think that makes sense to certainly get rid of that clause.
Okay. Thank you, Mr. Chairman.
Thank you. Number 16, Vice Chairman Reeves.
Caucus Vice Chair Gaines, thank you for bringing this bill. Representative Silcox mentioned there's no statute of limitations on murder, and technology. DNA evidence is one thing that brings it, confessions, witnesses, modus operandi or similar incidents in the future. Those are some things that can happen over time that could, break a cold case. One question I'd have, I looked at the bill. I like the Carl Vinson Institute database, and we heard the GBI and some other agencies that are, statewide. One thought on enhancing this bill, I would ask you to consider adding some language if the locals have exhausted their efforts and are not able to break a cold case, or don't believe that it's possible to break a cold case. Could the victims' families or parties in interest call on state agencies or others outside of the locals, and have that specifically in the bill? Because it looks like here you've got agencies general, but I think of the Tara Baker case, and I was a UGA Law School class 2003 member. I was still in Macon down at Mercer at the time that murder happened. But I think of Representative Stacey Evans and a number of law school classmates who were there when that happened, and decades later that not being solved. I think the locals in Athens have done everything they know how to do, but at some point calling on, the full power of the state of Georgia and exhausting all efforts. I also think of the Levi Frady cold case in Forsyth County I'm involved in a matter where someone who investigated that, Horace Trammell, he died over the weekend. He was investigating that cold case. He's now, his life is over, and that cold case has not been solved, and Forsyth County did all they knew how to do. But at some point, can we have a provision where if the locals have done all they know how to do, that the victims or the investigators can call on someone else? That would be one question there. And I applaud you for, removing practical barriers to statute of limitations on murder.
Be happy to look at some language, moving down the road. I think this is a great, step, and I don't suggest this is going to solve the issue. I do hope this helps solve some cases though, but be happy to look at, legislation in the future on that. Thank you.
Number 14, Chairman Leverett.
Thank you, Mr. Chairman. I wonder if the chairman would indulge me. I had a number of questions, some of which relate to amendments which the chair has proposed. The term murder is defined on line 31 as an offense under code section 1651. And I don't pretend to have the thorough sifting comprehensive knowledge of the criminal code that the chairman does, but is that an intentional unauthorized killing of someone, or is that does that involve premeditation? I wonder if we could use that definition to address some of the concerns the chair had about potential breadth of use of the word homicide up in line 20.
I think that just to make sure that there is within the purview of the investigation, we don't want to limit it just, to them having to determine whether it's a murder. We want to know whether, by striking that word, the thought is to basically have the wide latitude to determine what kind of homicide is it. You don't want to just limit it to murder.
So the chair's desire was to make the statute have a broader application.
Yes.
Okay. All right. So if we do strike the word murder in line 20, Mr. Chairman, I think we need to strike it anywhere else that defined term appears throughout the bill as well. Because I think it does appear a few places.
Yep. And Chair I would be fine with just limiting that to basically the definition of murder within that statute. We could just strike homicide and that be taken care of altogether.
Strike homicide?
Just strike homicide and have murder.
Right.
Yeah. Yeah.
Mr. Chairman, my friend from Prosecuting Attorney's Council just pointed out that murder doesn't have a statute of limitations, but other means of homicide does. So the words he was whispering in my ear just now, it needs to be murder.
All right. I won't be proposing that amendment.
So, Chair, would we then want to make an amendment? And I'm sorry to the vice chair of the caucus here. I don't mean to. I kind of feel like, I'm trying to practice. I do mostly civil work, so I'm trying to practice brain surgery when I should not be. But so
I'm not even a lawyer, so
I'm sure that's a source of pride for your mother. So,
but I am a politician, so
well, at least you're not both.
Right. Could be worse.
Line 20, cold case murder means a murder. Is that the suggestion?
It means a homicide.
I know that's what it reads, but is the suggestion to change homicide to murder?
Yeah.
I'm seeing some nods from someone in the crowd whose opinion I value.
Chairman Leverett, we'll get into this in discussion. I know we're still in a question phrase, so hold that thought.
Okay, all right.
Hold that thought. Number 17. Vice Chairman Reeves, your button was on? No longer. Okay, all right. Testimony to the bill.
You have remote
All right,
family members.
your audio. Good morning. If you would state your name for the committee.
Which family member are you referring to? Myself?
Yes, if you'd introduce yourself. I mean, I can see your name, Ms. Schroeder, but if you just introduce yourself and how you're connected to this bill.
My name is Meredith Baker Schroeder. I am Tara Baker's younger sister. I was 15 when she was murdered, and I am approaching my 40s.
Thank you for being with us this morning. If you want to go ahead and testify to the bill, this would be the appropriate time.
Thank you, Mr. Chairman. Thank you, committee members. On behalf of my entire family, thank you for allowing me to be present today and to speak in connection with the Coleman-Baker Act, or HB 88. I would like to thank this committee for their time and diligence with this important piece of legislation and that concerns cold cases across the state of Georgia. Today, however, I would like to share with you Tara. While most of you have heard that she was a talented student, she earned 2 bachelor's degrees in 3 years, and she was a dedicated first-year law student. But I want to share with you Tara, not just the photo that you see on the news every January for the past 22 years, but the person. Yes, Tara was brilliant, she was gorgeous, and she was successful academically. But she was the most meticulous and professional person I've ever known. And more importantly, in my view, it was the care that she gave to everyone and everything. She was truly the most thoughtful person I've ever known in my life. She was more than nice. She was kind. Tara negotiated car washes with friends for help on their term papers. She rescued one-eyed betta fish and refused to dissect animals in biology, instead opting to create models out of clay. She mediated squabbles between her siblings, and she would admonish friends and late night phone calls for them not having informed her of their safe arrival home. And she had a sixth sense of knowing exactly when to call to help build anybody up. The January before Tara's death, she came home for several weeks caring for my younger brother and myself, while our dad worked to keep the family business open. She would take us to school, pick us up, and help us with homework. At night, she would drive to the hospital where our mother lay, presumably dying from internal bleeding, a ruptured esophagus, and double pneumonia. She sat at my mother's bedside and held her hand and begged her not to leave. Now imagine my mother finding the strength to heal, to only lose her daughter exactly 1 year later. Now imagine not only losing your daughter, but to be denied her cause of death and to have no death certificate issued for 10 years, allowing her to continually be victimized through identity theft. And I would like to point out, Mr. Chairman, that the death certificate, when it was finally issued after a phone call from the governor 10 years later, contained 4 words: injuries consistent with homicide. That's all they had to do. And I know you mentioned Banks County. My husband is a prosecutor in the Piedmont District, which includes Banks County for the time being. Can you imagine walking up to a probate judge with a letter handwritten from the police asking for your daughter's estate to be probated? I'd like you to also imagine not knowing how she died. I wasn't permitted to read the autopsy report or to even look at photos for 21 years. Now imagine having to explain to your mother after years of having detectives act out scenarios only to be recanted time and time again. Now imagine having to explain to your mother how your sister actually died. Tara was a warrior and a fierce advocate for justice and a champion for the underdog. She was a true believer in right and wrong, And I can't help but think where we would be today if her case was given the same care that she gave to everyone and everything. For 22 years, we have not afforded her the justice that she deserves. To those in this room and who, every person whose desk HB 88 sits on, please give the police and the families the tools that they need to find their answers. Tara fought for her life. Now help Tara, victims, and their families get their justice. Thank you.
Thank you. Any questions from members of the committee? Thank you, Meredith, for being with us so early in the morning. We appreciate it, and our prayers are with y'all. Next, we have Natasha Bennett. Miss Bennett, are you online with us? Miss Bennett, if you would unmute yourself.
Can you hear me now, sir?
We can. Good morning.
Good morning. Thank you so much for allowing me to appear today. Mr. Chairman and esteemed members of the committee, I come before you today to advocate for the passage of House Bill 88, also known as the Coleman-Baker Act. This bill represents a crucial step forward in the fight to bring justice to the families of victims of unsolved homicides in Georgia. My name is Natasha Bennett. I am the first cousin of Rhonda Sue Coleman, and I am appearing on behalf of her parents today. Today was too emotional for them to appear themselves, but they want you to know that they wholeheartedly support the bill that is before you today. To give you a little bit of information about Rhonda, Rhonda was a beautiful and vivacious young woman who entered this world kicking and screaming January 18, 1972 in Hazelhurst, a small town in southeast Georgia where everyone knew everyone by their first name. They could tell you the name of their mother, their father, their grandmother, their grandfather, and every other member of their neighbor's family. It was a small town. In that world that she was born into, and from the time she took her first breath, her determination and vibrant spirit propelled her to make a difference in her world in Hazelhurst. And for 18 wonderful years, she exuded happiness and joy to those in our small town who were blessed with the opportunity to know her. Rhonda's laughter and smile could bring warmth on even the coldest of days. Her desire to help others was evident in her dream of becoming a pediatric nurse and caring for the most precious and vulnerable among us. As she walked out of her home for what would be the final time, her mind was focused on the future in college at Georgia Southern University. It was a future filled with so much hope and promise that was never to come into being. After spending the evening working on senior class activities, Rhonda said goodbye to her friends for what would be the last time and slipped away into the arms of God. Her car was found abandoned that night with the lights still on and the engine running. Her burned body was found 3 days later in a neighboring county. On May 17, 1990, Rhonda Sue Coleman took her final breath as she left this world, kicking and screaming the same way she came into it, at the hands of a killer whose identity has remained unknown for over 32 years. For 30 years, a crucial piece of evidence sat unprocessed in the evidence room of the Jeff Davis County Sheriff's Office. Its existence only became known to the family after a happenstance conversation with a retired Sheriff's Department investigator. And it wasn't until recently that this evidence was sent for processing, but only after Rhonda's family had made several requests for it to be sent. It was an oversight that could have been discovered earlier had her family had a process by which to initiate a cold case review. It was an oversight that may have led her family to suffer through untold years of additional suffering, waiting for answers as to what happened to their daughter on that fateful night. Answers that may come from the final processing of this evidence. Rhonda's case, like so many others, remains unsolved to this day. Across Georgia, there are an untold number of families who continue to wait for answers and justice for their loved ones, taken from them by senseless acts of violence, but they lack an avenue by which to request their loved one's case to be reviewed. The Coleman-Baker Act is a legislative step forward in the fight to bring closure to families who have lost loved ones to violence and to bring those responsible to justice. I urge you to support the Coleman-Baker Act and help make a difference in the lives of families in Georgia like Rhonda's. This act would also place Georgia at the forefront of the legislative effort to bring additional resources to state and local law enforcement to reduce the number of unsolved homicides across the state, and hopefully propel other states to consider similar legislation as the federal government has done with the passage of the bipartisan Homicide Victims Families Rights Act of 2022, which addresses the issue of unsolved homicides at the federal level. While Rhonda and Tara's cases may never be solved, we hope that you will bring meaning to their deaths through the passage of this act. And I would like to thank each one of you for your time and consideration, and thank you for your service to the state of Georgia.
And thank you, Natasha. We appreciate you being up so early with us. Next, we have Cameron Harrelson. You are the Baker family representative. Are you with us?
Yes, sir, Mr. Chairman. Can you hear me?
Yes, sir. Go ahead.
All right. Well, Mr. Chairman and distinguished members of this committee, let me begin by saying thank you for a few things. First, thank you for your service to our state. Thank you for your service to this committee, and obviously for your anticipated support of House Bill 88, the Coleman-Baker Act. My name is Cameron J. Harrelson, and I appreciate Mr. Gaines mentioning me previously, but I'm a resident of Athens, Clarke County, and I've called this city my home for the past decade. And while our town continues to celebrate 2 back-to-back national championships for our beloved Georgia Bulldogs, the city also continues to grapple with tragedy. The recent loss of a UGA football player and staffer, both killed in a car accident, the loss of William Ort Carlton, a town staple with a deep knowledge of our state's history, and our city continues to face one sad reality, that there are 40 unsolved homicides in our city government alone since 1970 that remain unsolved. Now, that number may seem small, but that translates into 40 individuals who are certainly more than just a case number or a statistic whose killers have not been brought to justice. 40 unsolved homicides translates into literal hundreds of family members, friends, and colleagues who have wondered for years, often decades, who killed their loved one and why. 40 cases for which our men and women in uniform go to bed at night thinking about, wondering what, if anything, they might have missed. 40 cases also means potentially 40 violent offenders who still call Athens, Clarke County home. One of those 40 cases, as we've already said, is the unsolved murder of Tara Louise Baker, a University of Georgia School of Law student murdered in 2001. And what I can tell you, Mr. Chairman, is how bizarre it has been to me for my life to be changed so greatly by a young woman who I never even met. 2.5 years ago, I started Classic City Crime podcast based in Athens to focus on some of our city's most prolific and unsolved homicides by putting victims' families at the forefront of those storytelling journeys. Tara's was the first case I covered, and I grew quite close with Meredith and the entire family. Miss Virginia, her mother, whose voice still shakes when she speaks of her daughter, she's had to relive her daughter's murder over and over again, and she is the strongest woman I know, even through all of that, reminding each and every single one of us every time she speaks that she is, quote, still Tara's mother. Her sister Meredith, who you heard from, such a bulldog for justice, who has, for years before I came along, or perhaps was even thought of, was advocating for her sister. And her brothers, Adam and Kevin, who look up to their big sister, 2 people she fiercely protected, and 2 men who continue to advocate for her all these years later. Throughout the course of telling Tara's stories, there were several things that I learned that really changed what was simply a podcast into a position of advocacy for myself. And that is this: there exists little resources for families of unsolved homicide victims to have their truths heard. Where can families go after a certain amount of time has passed to have their loved one's case reviewed? Where can they go for answers after the case has gone seemingly cold? And where can they find someone or anyone willing to listen? And yes, where can law enforcement turn when they need support to keep their communities safe? We also learned that these cases do not remain unsolved because of neglect. They don't remain unsolved because of a lack of desire by our police departments, sheriff's departments, and other law enforcement agencies. Instead, I found within each of them, and I've interviewed hundreds of them, a deep desire to see these cases solved. There is truly the desire for resolution at the heart of their service. But the reality is, Mr. Chairman, that with current crime continuing to occur and with the passage of time, there often remains little monetary, yes, but also personnel resources as well to give cases that are sometimes 10, 20, and 30 years old the attention that they deserve. I said there are 40 unsolved homicides in Athens, Clarke County alone, hundreds in the state of Georgia, and over 250,000 in the United States of America. Tara was known as the champion of the underdog, and I believe that we all have the collective responsibility to be her champion, to be Rhonda's champion, and to be the champion of hundreds of families across this state, to remind them that their loved ones' cases and lives have not been forgotten, but to ultimately answer two questions: who killed their loved one and why? I appreciate your time.
Thank you very much. All right. We have others signed up. We are at 9:21. We're going to have a hard stop at 9:35. Those that have signed up to speak to the bill have Ms. Jill Travis with Gackel. Good morning.
Morning, members of the committee. My name is Jill Travis. I'm with the Georgia Association of Criminal Defense Lawyers, and I want to just shift gears to words on paper and ask that you do strike the word murder on line 20, because the definitions within definitions and the way that the terminology is used throughout the bill. If you look, for example, on lines 37 and 38 regarding a cold case murder, now we bring in the definition of the word murder. To Chairman Gunter's point earlier, what if this was a suicide, but potentially it looks like a homicide until the full investigation has been done. You're limiting it by using the word murder at line 20, because what you're trying to say is if you use the word death for the word homicide, then you're always saying, okay, there's been a death. It happened 6 years prior. It was previously investigated. These are the criteria. And then when you use it in the statute, you're saying, and it is a murder. And so I think that the terminology is redundant, and it's also conclusory, because we don't know yet if it was in fact a murder. And so that's why I would ask you to consider striking the word murder on line 20. With reference to the conversation that was occurring on page 6 of the bill, just a couple of questions. I see the chairman's point with regard to some of the confusion. I have to say, just as I was hearing the conversation, part of what was going through my mind was, isn't there a writ of mandamus, or is it quo warrant? Thank you. I can never say that word. It seems like that certainly is certainly an opportunity to force the coroner or medical examiner to take action under current law. And to the chairman's point, using the agency's discretion seems weird. If you just take out at the sole discretion of the agency, then you're left with the question of who decides. And so that seems odd to me. And also the language about reference to this chapter. I think that the idea was probably this code section, not this chapter. It's a little confusing to me that we're going back to 1970 here in this code section, but we're only going back 6 years in the earlier. So we would certainly be supportive of the idea of forcing a coroner to do to produce a death certificate, but we think that the current law would allow for that. That's all I have, Mr. Chairman.
Thank you. Questions from members of the committee. Real quick, I'll just say it would sound like this can already be accomplished through one of the writs or both.
I think so.
Okay. All right. Vice Chairman Silcox.
Thank you, Jill, for coming so much today. Don't we need to limit this though, to go back to a certain date? No.
Yeah, I think you have limited it on line 21. You're limiting it to go back 6 years.
But that's just 6 years after the investigation was already conducted initially.
Right. I
I don't think we should limit it. Okay.
Well, it seems to me like if somebody's been killed and there hasn't been justice for it.
Okay. 8.
Number 17, Representative Fleming.
Thank you, Ms. Travis. A mandamus action can compel an elected official to do a duty they're required to do under the law. Is that correct?
No, I'm saying no, because don't ask me the equity questions. I'm sorry, Mr. Chairman. I can't tell you. I just know those writs exist to make people, force people to do things that they are supposed to do. And I'm sorry that I'm
No,
not.
you said exactly right. You just stated it another way, things that they're supposed to do. So if a coroner or medical examiner has discretion of when they shall issue a death certificate, a mandamus action would not be able to require them to do that because they're not required under the law. So my point is that a mandamus action, I don't believe it's going to resolve your issue here. I think what I heard the problem was that medical examiners are unsure that they have the authority to issue a death certificate. And what we're doing here is not forcing them to do it, but simply reassuring them you do have the authority to do that. So with that understanding, if you assume it's correct, and it may not be, you may argue that it's not, why strike this section?
I'm just raising the question.
Thank you.
All right. Somebody else had a blinking light, but it's went off. Anything further? Questions for Ms. Jill from members of the committee? You have none. Thank you.
Thank you.
All right. Okay, at this time, I'm going to assign this bill to subcommittee. We got some kinks to work out, which I think is fixable. I believe that we can accomplish what the bill author is trying to do. So I will be assigning this to subcommittee. If there's any discussion from members of the committee on it that you want to go ahead and hash out, I would expect, though, just to preface that, the bill will probably look a lot different coming out of subcommittee. So whatever concerns you might have now, you might want to save it because it may not be the same concern when the bill comes out in amended form. All right. See none, we're adjourned.